Sometimes people agree to agree just to be agreeable. Edgar Walker and Clarence Keith were so agreeable that they agreed to agree to do business if they could agree how to agree on the terms of their agreement. If that sounds like a mess, well, that's exactly what it was. The Kentucky Court of Appeals thought so too, as it tried to untangle the parties' lease agreement in Walker versus Keith. Walker, the landlord, leased a small lot to Keith, the tenant, for 10 years at $100 per month. The lease gave the tenant an option to renew for another 10 years when the original lease expired. The option clause said that the renewed lease would be on the same terms as the original lease except for the rent. The new rent would be determined, quote, in such amount as shall actually be agreed upon on the comparative basis of rental values as of the date of the renewal, with rental values at this time reflected by the comparative business conditions of the two periods, unquote. Don't worry if this sounds confusing, the court thought so too. When the original lease ended, the tenant notified the landlord that he wanted to renew. When the parties were unable to agree on the new rent, the tenant sued the landlord to enforce the renewal option. The trial court ruled for the tenant and ordered renewal at a rent of $125 per month. The landlord appealed.